You're listening to Let's Figure It Out by Ad Valorem, where we break down business, finance and tax without the fluff.
From side hustles to audits, we keep it practical, insightful and even a little bit of fun.
Let's get into it. Hello and welcome back to another episode of Let's Figure It Out, the podcast where we discuss all things finance. Today we're going to be discussing a topic that most like to avoid, but everyone needs to know about: wills and estate planning.
That's right. If you've ever thought, I'm too young for a will or I don't have enough stuff for estate planning, this episode's for you.
We're joined today by Kevin Barrett, Ad Valorem's trusted expert in estate planning. Kevin, welcome. Do you want to give us a bit of background about how you got into estate planning?
Hi, Luke and Sophie. Thanks for inviting me on. I'm an accountant by trade. I have been all my working life. And really, I guess I got into it through lack of action by clients. Having meetings year on year with clients where you advised them that they needed a will, they agreed, went off to see a solicitor and then came back the following year to say they'd done nothing, was frustrating to say the least. Ultimately, I did the training to be able to advise, and it was quite refreshing when a client came in to be able to say to them, look, I can do your wills for you, and all of a sudden action started to happen. It's something I enjoy doing. It's a conversation I enjoy having with clients. As you've pointed out at the beginning, it is a difficult conversation at times. It's not something people necessarily want to think about, but it's really important.
No, you're right, it is really important. And I guess to kickstart today, let's start with a little bit of an icebreaker. What's the weirdest thing you've ever seen included in a will?
I don't know, that's a good question. I don't know that there's anything that's ever struck me as a wow factor kind of thing. I think I would probably approach it from a slightly different angle, in the sense that often it can be the smaller things that are as important. A lot of people will think about the bulk of it, but leaving something like a very small keepsake to a friend or a remoter family member can be as important to the person making the will as what happens to the bulk of their estate. I guess if we're talking about things that people wouldn't necessarily think about, the children and then the pets are probably one that comes as a bit of a surprise to people that we start discussing that. And there are some funny conversations that we have when we start discussing where people would like to leave their children to, kind of thing, and who they would like to dump them on.
I think there's always something as well, isn't there? Like my father-in-law's got a Land Rover Defender, and it's just gorgeous. It's like 30, 40 years old. So expensive to run. Don't know why anyone wants it, but for some reason it's the hot debate in the family is who's going to get the Defender. So I think there's always something in someone's family. So
yeah, I mean, I was talking to friends the other day because I'm doing my will at the minute, and they have said that they are leaving their 2 dogs to named persons, and whoever takes the dogs will get 50 grand for each dog. So I threw my name into the hat.
Me too.
But no, it's important, and I think especially with wills, something that's really important is the continuation of someone's legacy. And I think you're right in what you're saying. It's an important thing, a difficult conversation, but very important to have during your lifetime.
Yeah.
Why don't you talk us through what happens when someone doesn't have a will and they pass?
So in simple terms, I guess the starting point, if somebody doesn't have a will, the technical phrase for it is dying intestate. So you'll see that if you search. You leave everything to chance to a degree. There are a set of rules, legal rules that apply to what happens to your estate, but all of that is out of your control, and your assets may not pass to who you would genuinely want them to. They may lack the protection that they need. And therefore, I believe that nobody, regardless of their circumstances, really should be dying intestate.
So to draw it back, what does dying intestate, what does that actually mean?
So basically, your estate will be distributed in respect of statutory rules.
Right. Okay.
So an unmarried couple, the assets wouldn't pass to the other half. They would actually potentially again go to the parents. If there are children, maybe go to the children. So there are unexpected circumstances of dying intestate.
I suppose you could see that's going to cause a lot of dispute potentially as well. And
am I right in understanding that also some of your estate could actually end up going back to the state? So it could end up going back to...
Yeah, in an absolute worst case scenario, if there is no living family member, then the government will get the whole lot. Slightly different rules for Cornwall and Lancaster, because they actually go to the duchy, but I mean essentially it goes to the crown, which in a sense is the is the state.
Wow.
And therefore, again, something we will look at when we do planning with people is, again, what we would refer to as a backstop beneficiary kind of thing. So even in a will, assuming that everybody has died, at least name a charity or something like that you would want it to go to, rather than letting it go to the government.
There you go, people. If you don't want it going to Rachel Reeves, write a will.
Exactly.
Basically. Okay, that's interesting. So you mentioned about giving to charity and things like that. So how does that work in a will if somebody wants to leave a large sum or even a notable donation to a charity?
So again, you will list a set of beneficiaries using the example I just brought up. You've got a situation where all of your beneficiaries have died, there's nobody for it to go to, and it goes to a charity. The charity will just be listed, named as a beneficiary. Now, you can do that either naming a specific charity, or you can leave it to the choice of your executors, the people who will carry out the wishes of your will, to make a relevant choice. If you're going for one of the big charities, then they're likely to be around in 20, 30 years' time. If you're going for, your local cat's home that, you fostered a cat from, then you may need to be a little bit careful, because that charity may not exist at the point you die.
Well, it depends how much money you're giving them, I guess, doesn't it?
Well, yeah, absolutely.
So with that then, you just touched briefly on executors of a will and things like that. So once somebody passes, the executor will execute what the deceased wishes are. In terms of gifting to charity and things like that, how is it that that's then tracked back? So is it something that when you're alive you tell the charity, I've included you on my will, or is it something that you just have to kind of trust that the executor will execute?
Yeah. Essentially, the executor's role is a legal duty, so they have a duty in law to carry out that wish. No, there isn't a need to tell the charity how the charity would find out. So it's useful perhaps to say that once you die, your will is published, so it is available. So anybody who has died, it's possible to go online and find a copy of their will. It's a public record. So obviously a charity can track that they've been left something in their will, and if they haven't received that, they can take action. Clearly, your choice of executor is really important. It's somebody you trust, and somebody you trust will carry out your wishes. It's sometimes difficult, potentially, if you choose, one of your children to the exception of another, that could cause friction further down the line if the one who's not an executor feels that they're not getting what they should have done. But no, I mean, essentially your will is private to yourself. You write your will. You have no requirement to tell anybody what you've put in that will, whether that be an individual, an organisation, or a charity.
Okay. And am I right in saying, so there's kind of two elements to the will as well? So we've got the legally binding document, but there's also the softer side of the wishes. So can we talk a bit about those? Yeah.
Generally speaking, the letter of wishes will more come into account where there is a trust added into the into the will. But yes, a will is a legal document. There is no scope for doing anything other than what is included in the will. However, if you leave something in the will that says at the discretion of my executors, my trustees, then alongside that you can do a soft document, the letter of wishes, that will allow you to stipulate what your wishes are. It's not legally binding on the executors or the trustees, but having said that, if a beneficiary went to court and that document came up, the court would look unfavourably at a trustee that hadn't taken actions within the letter of wishes without good reason. I mean, a good reason for not having carried out the letter of wishes would perhaps be a change of circumstances of the beneficiary that would make that unwise, or potentially a change in legislation that means that doing it in that way would be more tax inefficient.
Yeah, okay.
Interesting. And just going back to dying intestate and comparing it to if you had a will, I guess one of the things whenever you deal with statutory things, tends to extend the process and timelines. I'm curious as to the potential drawbacks of that, because I'm sure there'll be some listeners that will be thinking, well, actually, it's not necessarily going to affect me. What are the challenges? I guess what other things that need to be taken into account then?
So when you die, the process, depending on whether you have a will or don't, is slightly different. If you have a will, you've already stipulated, as we've said, who your executors are going to be, and there is a process of obtaining probate. Probate is in simple terms, it's the process of getting court authority to enact that the wishes that are in that will. If you die without a will, then essentially you have no appointed representative. So somebody then has to approach the court and say, are you happy for me to deal with this estate? And the court has to issue a document kind of thing that essentially mirrors probate but isn't.
So what if someone has absolutely no one? Do you think there are instances in society at the minute where people have passed, didn't have anyone, they've got bank accounts with money in, and it's kind of just sat there?
No, I mean, essentially the court would, on death, if somebody died intestate without anybody to step in and help out, the court would appoint an independent person to do that. So it'd probably be a lawyer or an accountant, generally, who would be appointed to step into that role and deal with the estate of that person. And obviously, there are firms out there who will investigate potential beneficiaries kind of thing. So we'll dig back into the family tree and find,
get on Ancestry.
Third cousin twice removed kind of thing, who will be contacted and say, look, you've just inherited Uncle Henry's estate.
We all hope for that day.
Yeah.
Presumably that's more expensive as well, though. If you're having to pay for estate planning services or whatever thereafter, the actual management of the estate thereafter is going to be more expensive, I would imagine, than if you'd already had a will and you'd almost...
Yeah, I mean, the more complex it is, the more time is going to be taken. And bear in mind that those professional executors are going to be charging for their time. So that, in its own right, reduces the value. If you've died with £10,000 in your in your bank account, and somebody has to go searching for a beneficiary, there may only be £2.50 left for that beneficiary once they're actually found.
So, I guess another thing, just to kind of cover off, I think one of the misconceptions around people passing and actually the timeframes that are included in that. So can we just talk a little bit around how long it tends to take to execute a will and actually obtain probate post-death? Because I think a lot of people think, oh, someone passes away, the next day's the funeral, and then the will's being read and that's it.
Yeah, I mean, it's the legal part and the form filling that takes the time, and like any interaction with government and court, it takes a long time. For simple wills, it can be a month, 6 weeks at best. if the wills are more complex, need more work, then actually getting that probate can take a lot longer. Now, one other thing that people face, and it's something we look at when we do estate planning, is the fact that you can't obtain probate until you've paid HMRC or come to an agreement with HMRC about the inheritance tax bill. So you end up in a situation where you can be in a catch-22. You don't have the cash to pay the inheritance tax until you can, say, sell a property or sell assets, but you can't sell assets until you've got probate. So you do find yourself in a bit of a catch-22. Now, there are ways and means of negotiating, getting round that, but it's not. It can be a very, very time-consuming. It's not unusual for it perhaps be 6 to 12 months before an estate is at a point.
And I think this is the big issue that we're probably seeing with farmers now, right? With inheritance tax changes for those guys and people actually not being cash rich. So when the granddad who's owned the farm for 70 years passes away, they're having to sell the farm to actually pay HMRC. So it's not a convenient time.
No, if you look back in history, I mean, we've got examples of that. Okay, it's the ultra rich kind of thing, the landowners, the stately homes and that kind of thing. And the reason lots of them are, now in the hands of National Trust or whatever is the fact that death duties and what have you came up. Yeah, you might have an asset that is worth a lot of money, but unless you've got the cash to pay the tax on that, your only option is to sell that asset.
Taxman's getting you at every hurdle.
Absolutely,
Yeah.
Basically.
So I guess moving on to, the actual ways you can plan for it then. So you've obviously established some of the issues with not having a will and things. What can you do to make sure you're best prepared? And what sort of planning do you typically do?
So it varies really, dependent on the on the type of client I'm seeing. For a lot of people, what I would class as a simple will, something that is relatively cost effective, will at least set out the wishes of that person, will be sufficient at a certain stage of life. However, further down the line, there may be a lot more considerations to take in, and therefore we're looking at, largely there are two main areas that people are concerned about. One is inheritance tax. Nobody likes paying tax, and people particularly hate inheritance tax.
Taxed on tax money, isn't it?
Absolutely.
Basically.
And the other is making sure that the assets are left to where they want them to go with sufficient protections in place. I always have a discussion with clients about what I call reach beyond the grave kind of thing. How much control do you want to have over what you leave after you've gone? Some people will be very blasé about it. I'll leave it to my children. If they fritter it away, then that's their problem. Others will be much more, I'm leaving this. I don't want my children to have the problem of handling that amount of assets, and therefore I want to put in place something more structured that somebody is managing that money.
Yeah, I think particularly in today's day and age, the younger generation aren't used to handling that much wealth if it's a substantial amount of money that's being passed down. I think that's probably a fair assumption that I think people with a lot of wealth would want to make sure that they're being supported adequately, I guess, beyond that.
And I think also planning your will, sooner rather than later, allows you to be more strategic around asset distribution during your lifetime to help mitigate inheritance tax. So if, that's something that you're worried about, the sooner you establish your will, establish what your estate looks like, you've got more opportunity to move things around.
Yeah, I mean, it's in one example of that is the fact that you can give away money, and during your lifetime, every time you give away money, you have to survive that gift by 7 years. Now, if you're using trusts, for instance, to deal with that, that's 7 years kind of. You have to wait for it to reset. So the earlier you start doing that process, if that's there, gives you more opportunities. An 80-year-old is probably only going to have one bite at that seven year. A 50-year-old may have 3 bites of that 7-year kind of thing. So there's much more scope to doing work if we're speaking to somebody earlier on in their in their life.
Would you prefer to start the estate planning before they've had their will written up, or is it typically something that what order would you do it in?
So yeah, the estate planning part of it will be the first part. Okay. The actual legal documentation of that, so the will, any trusts if necessary, lasting powers of attorney, that kind of thing, will follow on from that. Now, in some cases, what we'll do is maybe sit down with a client and say, look, if you've got no will at all, we need to put something in place as a stopgap. So we'll put a simple will in place so that if they die while we're doing the planning, obviously I prefer they didn't, but if they died during the planning, then at least they're protected to a degree. Then we'll continue to do the planning and put in place more formal stuff further down the line. So you're kind of protecting yourself with a base. And then moving on and doing the planning. So that's about the only time I would do a will first before we've done the work.
And how often would you need to review the will and the estate planning? Is it an annual thing? Is it biannual?
Generally speaking, I would say you should be reviewing your will. And by reviewing, I think, that can often come with connotations. You should just be reading your will and confirming to yourself that those are still your wishes. There are key life stages when you probably should be doing a new will. So marriage would be one, having children be another, buying your first home would probably be another kind of thing. So those are 3 examples of trigger points when you should be asking yourself, have I reviewed my will?
I suppose selling your business as well is a big one.
Absolutely. Yeah.
Asset value goes up significantly. So, Kevin, I think it'd be good just to chat through some of the other documentation as well around wills and estate planning. So, what other things are involved?
Okay, so obviously the basic will itself is kind of a starting point, but there will be other documents surrounding that, for instance, trust documents and the such like. Another one that's a major one that we discuss, and to be honest, it's probably a podcast all in its own right, are lasting powers of attorney, or LPAs. I often think to a degree that LPAs are more important than your wills, because you will be dead by the time your will is read, so it affects other people. If you lose capacity, that is the ability to make decisions for yourself. By having a lasting power of attorney in place, somebody you trust can make decisions for you. There's often a misunderstanding, again, if we look at a husband and wife scenario, that if, let's say, the husband loses mental capacity, that the wife can just step in and manage the affairs. That is not the case. You'll often find assets are frozen. If, for instance, the house is in the husband's name, the wife cannot take out insurance in there. It is a massive, massive headache during the lifetime of the person. So therefore, often when we're doing the estate planning, as an aside to a degree, we will also discuss lasting powers of attorney and whether people have got those in place.
Okay, awesome. And that would be... as part of if you were to do that simple will, just looking at the process from start to finish, could people have lasting power of attorney without a will? Or
they're completely independent. So there are 2 types of lasting powers of attorney. There's a health and welfare one, and there is a finance and property lasting power of attorney. So potentially you need both of those in place. One of the advantages of the financial lasting power of attorney is that the person who is making that power of attorney can actually put that into force before they lose capacity. So let's say your parents decide to go on a round the world cruise but need somebody to keep control of their properties or what have you. They can give you power under their power of attorney to act in their stead while they're away, and then they just withdraw that authority once they return.
Okay, makes sense.
So I guess that's the LPA is effective on a personal basis, so for your home life. How does that then feed into business owners and their business life?
Yeah, that's a very interesting point. You can do what are called business LPAs. That's the description that is generally used. A business LPA is no different from a normal LPA. The reason is that you can do multiple finance and property LPAs and specify different people to act on your behalf. So if you're the director of a company, you may not want your wife to step in and run it if you lose capacity, kind of thing. You may want to appoint a business person who can manage that affairs. So what you would do is you would do an extra lasting power of attorney that specified just that particular aspect of your business and gave authority to that person, and then you would have a lasting power of attorney that dealt with your personal affairs on there. So it's a really important thing for business owners to consider, and this is not just for lasting powers of attorneys, but also the will of what happens to your business when you lose capacity or die, because it may not be that somebody can step in there, and for business owners that's really, really important.
Yeah, unfortunately, I think we've heard of clients have had a few horror stories around that, where things like banks have been frozen, and when families are going through grief anyway, to then have the stress of the business completely stopping function is something you don't want to be dealing with. Not
to mention the fact that if you've got a reasonable sized business, you might have employees there, and if the bank account's being frozen, it's not just affecting the business and that, it's also the fact that the employees potentially can't get their wages, and so they're feeling aggrieved as well. You don't need the added burden, so you need to be looking forward and saying, how is this going to work?
Okay, Kevin, we're going to do a quick fire round. I'm going to give you 3 assumptions and you let me know if they're true or false. First one: if I die without a will, the government will get all of my stuff.
False. It can happen, but you'd have to die without any relations that could be located, and that is very widely drawn.
Okay. If I die, my spouse automatically gets everything.
False. There are set rules for this. Firstly, you have to be married or in a civil partnership for it to pass, and there are limits. So only the first 250,000 of your estate will automatically pass to your spouse. The balance actually goes to your children, albeit there are certain rules over that. It's only half of the remainder goes to your children.
And then the other half goes to...
The other half goes to your spouse.
Okay, perfect. And wills only matter if I own a property?
No, wills matter regardless. Wills are your statement of wishes of what you want to leave. Doesn't matter how much value is there. It depends on the definition of property. There, if we're talking about land and buildings, you can only leave physical items. One interesting anecdote on that is obviously we're now much more in the era of digital. You can't leave your digital record collection, so your Amazon Prime or whatever it is, Spotify account, that dies with you, kind of thing, whereas people who've got large collections of LPs or CDs, obviously they are physical products, those can be left.
It's a real shame, because I've got some good playlists on my Spotify that to benefit from.
Whether your children at that point would agree is another matter.
So, in terms of inheritance tax, when you're dealing with larger estates that have got individual items, for example, cars or jewellery, how would you go about valuing those, and how is the inheritance tax paid and by who?
Okay, I mean, in terms of the valuation, we're starting to move a little bit into kind of the probate section. So it's the executor's duty to obtain valuations and report those to both HMRC and the court on the necessary returns. Now, in terms of who pays the inheritance tax, ultimately the liability lies with the executor to get those. It will be down to the drafting of the will of who is ultimately responsible. So if, for instance, you've got, let's say, an expensive piece of jewellery that you want to leave and you don't want that to have to be sold, then you need to actually specify that the recipient is receiving that without inheritance tax being deducted, and the remainder of the estate will suffer the inheritance tax. So to use an example, let's say that piece of jewellery is worth £100,000. That's going to have a £40,000 inheritance tax charge on it. The rest of the estate has got to have enough in it to cover that inheritance tax. If it doesn't, then ultimately the executor's only option is to sell that asset to get the money, or for the beneficiary to actually stump up the money and give that to the executor to be able to pay the inheritance tax. So it can be an awkward conversation, but it comes down to the estate planning side of things, in the sense that my job is to look at that kind of thing and say, right, okay, what are the complications going to be further down the line? I don't have a crystal ball. I don't know what their circumstances are going to be, when they're going to die, or what the government is going to do in the meantime. But we can certainly plan that so that...
So in that respect, sometimes it can be the case that actually inheriting things from someone's estate can be a bit of a hindrance as well.
It can be, yeah. If something is not planned correctly and looked at and defined, then yes, it can be a massive headache.
So for items that appreciate or depreciate in value, for example, so I mean, to be honest, you know, whiskies,
Baseball
vinyls,
cards.
baseball cards. Yeah, I collect baseball cards. For those that don't know, they appreciate and depreciate in value. If I buy something at 50 quid, but actually in 30, 40 years when I die, its perceived value is 10 grand plus or whatever. How do you know? Yeah, because I could list something on eBay for 10 grand, but it's not actually worth, or someone tells me it's worth 10 grand, but it might, oh yeah, I bought it at 50, so surely that's the 50 quid, so surely that's the, I don't know. How do you work that out?
You would have to go to, I mean, ultimately you would have to go to a professional who can put a valuation on that specific asset. So using that as an example, you've got your £50 baseball card. At the point of your death, an expert says it's worth £10,000. Now, it is possible after the event if you make a loss on that. So if ultimately a month later your executors sell that and they only get £1,000 for it, you can at that point go back and amend your inheritance tax calculation to claim back the excess tax you've got, or alternatively the beneficiary at that point would acquire that asset at £10,000, and if they sell it, then they make a loss which they could potentially use to offset a gain of their own.
Yeah, but if you, it's I can see how it gets lengthy and complicated, right? Because if you've got multiple different collections, like if you've got baseball cards, whiskey, wine, all sorts of different stuff, and they're specialists in their own different LPs and vinyls and things, you know, that is, I can see how that. You then need to get an expert valuation on everything.
Yeah.
Sell it before you go.
Yeah.
I mean, generally speaking,
or gift it. And then wait 7 years.
Generally speaking, what we accumulate during our lifetime are technically called chattels. those are generally left out of the estate unless there's any, for inheritance tax purposes, because they're deemed to be depreciating assets, kind of thing. So they're left out the estate. They're not valued. So you don't have to value your grandmother's armchair that's in the corner that's got sentimental value but actually doesn't have any real value at all there. But you've got your executors would have to look very carefully at things that are antique or collectible kind of thing, and therefore have a value. I guess generally speaking, you would look at it as why did you acquire those kind of thing. If it was we all do it, whether it be baseball cards or cars or whatever kind of thing. But some of it can be down to just enjoying having that item. Others can be because you do perceive it's got a future value to it. And generally speaking, if it's got a future value and it's appreciating, then it's going to be relevant for inheritance tax. But it's not a hard and fast rule. You can't look at everything. And it can be in the hands of one person, it can be one thing, and in another person's hands, it can be another.
Well, exactly. Yeah. I mean, you might have some things only there's one person in the entire world that wants it.
Yeah. Like baseball cards.
Whoa. Maybe in the UK. But yeah. So, Kevin, if you had one key takeaway, what would it be?
Well, I guess the short answer is do a will. Make sure you've got a will.
Whether it's simple.
Just
something.
Everybody should have one.
And what's the biggest mistake or misconception you'd warn people to avoid?
I think there's a misconception about when a will becomes invalidated. Divorce and marriage are two common ones that I have the conversation with people about. Actually, marriage invalidates your will, so it's worthwhile being aware of that. If you've already got a will and you get married, that will be invalid. If you get divorced, your will is not automatically invalidated. The reading of the will is done in such a way that your ex is actually treated as if he or she had predeceased you. So in reading the will, you ignore that person for the purpose of a legacy. So that's quite a common misconception. And as I say, it can be a planning faux pas for anybody who gets married. And we often look at it with regards to remarriage, of what happens to assets if you remarry after one partner has died. How do you protect their element of the estate from going sideways?
If this episode's made you feel like you've been putting it off, good. It's time to act.
Yeah, it's not about being morbid, it's about protecting your loved ones. You don't have to be a millionaire to need a will. You just need to care about what's going to happen next.
That's it for this episode. I'd just like to thank Kevin for joining us.
Thanks for having me.
That's it for Let's Figure It Out.
See you soon.
See ya.